Welcome, precious viewers, to Gunjana Lagos Discourse on Law of Trusts. Today's video is the fifth video on the topic classification of trusts and the second video on charitable trusts. So we are to continue in this video with the discussion charitable trusts. In the last video, I discussed one of the classes of charitable trusts, which is the trust for the relief of poverty, and I was able to state which classes of people can be considered as poor for the purpose of any trust for the relief of poverty. So I believe you have seen that video. Do well to see it. In this video now, we have to look at other categories of charitable trust as outlined by Lord McNaughton. The next one is trusts. The next category of trusts, the second aid of trusts as laid down by Lord McNaughton, is trust for the advancement of education. Trust for the advancement of education. So if a trust is for the advancement of education, then it is a public trust. It is a charitable trust. The question now is, which type of education will qualify? Which type of education will be regarded as education for the purpose of this trust? Well, fortunately, the courts in construing education for the purpose of trust for the relief trusts for the advancement of education have not the courts had been very liberal in their interpretation. The court adopted a broad interpretation of education. So education had been construed not to be limited to formal education. The court had interpreted education by not limiting it to formal education, in, for instance, education in schools, in classroom, education in colleges, universities. The court did not limit the meaning of education to formal education. Education that is being regulated, where you be issued a certificate. So court did not construe education in such a limited manner. The court did not give it a narrow interpretation, but it was given broad interpretation. Therefore, education in this sense also include aesthetic education, such as appreciation of art, music, or dance. So even education for any education or any acts that will promote or that will advance music or advance singing and even arts, Then it also constitutes education for the purpose of this trust. So it has education. The important point is that education has been given a broad meaning in this regard. Now let's see example of trust. Example of trust that have been held to constitute a trust for the advancement of education. Before that, take note that the requirement of public benefits, is very sacrosanct, is cardinal, is very important for trust for the advancement of education. All categories of public trust except trust for the relief of poverty must satisfy that requirement of public benefits, which we shall subsequently see the requirement for public or charitable trust. But take note, is very important. Subsequently, we shall say illustrative case also. Now let's look at some example of trusts that have been held to be trust for the advancement of education. First, we have trust for the foundation of professorships, lectureships, and scholarships in a university. So a trust that was set up for the foundation of professorships, lectureships, scholarships in a university has been held to be a trust for the advancement of education. And that was in the case of Attorney General versus Margaret and Regius, professors at Cambridge. Regius professors at Cambridge. That was the case in which that trust was held to be a trust for the advancement of education. Also, a trust for the provision of prizes for sport in a school had been held to be a trust for the advancement of education. And that was in the case of remarriage. In remarriage, that was where it was held to be a trust for the advancement of education. Also, trust for the encouragement of chess playing in Dupree's trusts. The trust was held to be a trust for the advancement of education. And trust for the encouragement of choral singing in the case of Royal Choral Society versus IRC. So that trust was held to be a trust for the advancement of education. So those are examples of cases in which a trust was held to be example of trust that were held to be for the advancement of education. The next one is the trust for the advancement of religion. Trust for the advancement of religion. The operative word here now is religion. So the question now is, what constitutes religion for the purpose of these trusts? Just like in education too, the court had been liberal in their interpretation. So equity is tolerable in this regard and did not sideline any religion or consider any religion as inferior with respect to religion for the purpose of trust for the advancement of religion. So what constitutes religion here? All forms of religion is is recognized. All forms of religion is recognized. No religion is discriminated against in respect to trust for the advancement of religion. So any form of monotheistic theism is constitute a religion in this regard. Any form of monotheistic theism, any form of religion in which the adherents of that religion believe in a supernatural being. Any form of religion where there's a belief in a supernatural being who is entitled to worship is accepted. The only exception is that such religion must not be subversive to morality. Such religion must not be against morality. That's the only limitation. Otherwise, all religions are welcomed for the purpose of trust for the advancement of religion. Also very important is the public benefit element. The public benefit element is very sacrosanct in order for a trust to be valid as a charitable trust for the advancement of religion. It must satisfy a public benefit element. So this trust is not only limited to the worshipping of that supreme being, but even maintenance of place of worship also constitutes. So any trust for maintenance of place of worship also constitutes a religion. Also, the court will not consider the numerical strength of that religion. The numerical strength of that religion is not considered. So if, for instance, that religion is such that its adherents, its followers are few, the court does not take that into consideration. So numerical strength of religion is not a determining factor. It's not a determining factor. So let's see some examples. The next is, let's see some examples of trust that have been held to be trust for the advancement of religion. But with respect to the public benefit element, which is very sacrosanct for trust for the advancement of religion, I have a case here where the court re-emphasized and reaffirmed that element. In the case of Fatumola versus Ogundimu. Fatumola versus Ogundimu. In that case, the court re-emphasized the public benefit element and held that in order to qualify as charitable trust, it is an essential, very important element that they should benefit the public at large and not a section of it, and not only members of a religious sect. So the trust for the advancement of religion, in order to qualify as charitable trust, must benefit the public at large and not just for only members of a religious sect. So that's what the court reaffirmed in that case. Now let's see some example of trust that have been held to be for the advancement of religion. Example of trust is one, trust for mission work. Trust for mission work in the case of Raymond's will trusts. So trust for mission work was held to be a trust for the advancement of religion. Then trust for God's work in the case of Rebecca. Trust for God's work in the case of Rebecca. Also trust for the increase of salaries of clergymen. In the case of it seems there's a mix of there. Let me start again. Trust for the mission work is in the case of is in the case of yes, I'm correct, Removes will trust. Then trust for God's work in the case of Rebecca. Then trust for saying of masses for the dead in the case of Rickhouse. There's trust for saying of masses of the dead. Then trust for the fitting of a stained window in a church in the case of Rick King. Then trust for church choir in the case of was held to be a trust for the advancement of religion in the case of Royce. So the examples are many and they are inexhaustive. So those are some of the examples. The last categories of charitable trust is other purposes beneficial in the community. Other purposes beneficial in the community. So this is the last classification as given by Lord McNaughton. However, this classification is still bringing us back again to the problem that we had, the difficulty we had in determining what actually constitutes charitable trust, because this aid is the residual aid provided by Lord McNaughton, and it is also an omnibus aid. So to determine the trust that will fall within this category is another problem. It's a problem, and as such, the scope and the limitation of this aid is difficult to decipher, to determine the scope of this or the extent. Is difficult to delimit accurately the extent of category of charitable trust on this aid. That's the difficulty with this aid, but all that can be said and is important is that the trust must fall within the words, the spirit, and the intendment of the statutes of Elizabeth. That's all that can be said. So this aid is too wide that its scope cannot be determined. That's another, or the limit. That's another important thing or point. And we have examples of trust that have been held under this heading. We have trust for the provision of hospitals in the case of Smith. Then provision of a fire brigade in the case of Rewalkingham. In the case of Rewalkingham. And the list continue. Protection and benefit, trust for the protection and benefit of animals. The problem with this particular topic is the cases. The cases are too much. And it is the cases are susceptible to confusion. You can mix them up. But for me, what I did, or what I usually do whenever there's a topic that has several cases like this, I always have a list where I put them down and where I can always grade them. So I'll put them down on my table, and then I can always grade them at any time. For instance, some morning when I wake up, I'll go and greet those cases. Good morning, sirs. Good morning, ma. Good morning, Carisbrick. Good morning, Godam. Good morning, Smith. I'll be greeting them like that. Some I can also greet them in the afternoon, in the evening, and even more than 3 times, as much as I can. Then by the time you know, they will be sticking. They will be sticking. So that's how I do personally, because in this kind of topic, actually you can either be asked to write generally on charitable trust, or the lecturer can just bring one example of that trust and ask you to discuss the validity. So if you don't know the case, you will not have a better way to start. Now, so that is that. Then finally, let's briefly discuss the requirements, the essential requirements of charitable trust or for charitable trusts. The requirement for charitable trusts, as I've mentioned earlier, is that it must have a public benefit element. It must have a public benefit element, and by extension, the class of the intended beneficiaries must not be related to the settled law. So these two requirements, they are just related, because if the beneficiaries are related to the settled law, then it has lost the public benefit element. But so the major element is actually that it must have the public benefit element. Then by extension, the class of the intended beneficiaries should not be related to the settled law or donor. So the public benefit element is that it must not be for private purposes or benefit certain private individuals, or the intended beneficiary, or the criteria, the basis for choosing the beneficiaries should not be because as a result of their relation with the donor. Otherwise, it has lost this element. So this element is a cardinal requirement. It's a fundamental requirement. It's sacrosanct. It's very important. Otherwise, the trust will fail. And there are some illustrative case where trust failed for lack of this element, because this element is wanting. And one of such popular case is a Nigerian case, the case of Inyanda versus Ajike. The case of Inyanda versus Ajike is one of the cases where a trust failed for lack of a charitable trust failed for lack of public benefit elements. In that case, the testator by his will appointed trustees and provided that they should let one of his houses and use the rent and profits for the maintenance of a family prayer room in another of the testator's houses. Their prayer room was described as a private mosque. It was held that since there was no suggestion that members of the public were to be admitted to the mosque, the trust lacked the essential element of public benefit. So the testator directed that a particular room should be rent, and then the rent from it should be used to maintain a family prayer room, which was described as a private mosque. And it was not shown that members of the public will be admitted into it. So the court held that it lacked the public benefit element, because it seems to be restricted to the testator's family and just his religious sect. So it lacked that element. And in that case, Becker SPJ said religious purposes are charitable only when religious services tend directly or indirectly towards the instruction and edification of the public. So the public is the overriding requirements and the overriding principle. So that's an illustrative case where a charitable trust failed for lack of this public benefit elements. Another case is the case of recompting. In the case of recompting, a trust also failed. In that case, trust for the education of the relations of a particular person failed for a lack of public benefit element. So the trust was for the education of the relation of the donor, and it was the class of the intended beneficiaries were very related to the donor in the case of recounting. So the trust failed for public benefit elements. So another illustrative case is the case of Rehoboam Pedro. Rehoboam Pedro, where the trust was for the education of the children and grandchildren of the testator. The court relied on the case of recounting and held that that particular trust failed. The testator there actually created two categories of trusts, but in relation to this particular one, the one for the education of the children and grandchildren of the testator, the court held that it lacked the public benefit element, so it failed as a charitable trust. Now, one point to note is that the fact that the number of intended beneficiaries is small may not bereft or rob that trust of its public benefit feature. So that a charitable trust is required to have a public benefit element does not mean that if the class of the intended beneficiaries is actually small, then it has lost that feature of public benefit. No, it is not so. In a case where the class of beneficiaries were small, it was also held to be a public trust. So number may not actually be the determining factor. So on the other hand, now the fact that the class or the number of the intended beneficiaries is actually large, the beneficiaries are many, may not give that trust to that public benefit element feature, that the beneficiaries are large in number, or the beneficiaries they are many, does not mean that it has satisfied the requirement of public benefit element. So you can see, there's a case that actually illustrates that, where the number of beneficiaries were running into over 1,000, yet the trust was held to lack the public benefit element. And there's the case of opium versus tobacco securities trust. So in opium versus tobacco security trust, the trust was for the education of the employees of a particular employer. So a particular employer created a trust, set a trust for the education of his employees, and the number of beneficiaries run into over 1,000, yet the trust failed for lack of public benefit elements, because the criteria of choosing the beneficiary was based on personal relationship, which is the second limb of the requirement that the intended beneficiaries should not also be close or related to the donor. So in this particular case, now despite the number of the intended beneficiaries, the trust was not spared. It failed for lack of the public benefit elements. Finally, take note that the exception, as I've stated before, to this requirement of public benefit element is the trust for the relief of poverty. The trust for the relief of poverty, and you will see that in one of the illustrative cases when we are talking about a trust for relief of poverty, that there was a trust that was set up for the education. There was set up for the poor relations, the poor relative of the donor. It was held to be, it was upheld. The trust was not held to be invalid, or the trust did not fail, since it is a trust for the relief of poverty. So trust for the relief of poverty is the only exception to this requirement of public benefits. So that brings us to the end of this discussion on charitable trusts. In the next video, we shall continue with other classes of trust. We still have implied or resulting trust and constructive trusts. See you then. Thank you.